Judges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge?
Say that again.
So to the charge, let's start with just evading arrest or detention with the...
This courtroom hearing starts off tense and only gets more heated from there. A defendant already serving time for murder walks in facing another serious charge, evading arrest with a vehicle. But instead of a simple plea, what unfolds is a confusing back and forth with the judge about legal terminology, plea options, and courtroom respect. The stakes are enormous. Accept a deal for 18 years, or risk going to trial and facing 25 years to life. The question is, will this defendant cooperate, or push the judge to the limit?
Use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my court, you either enter a plea of guilty or not guilty.
Guilty. Okay.
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no contest because he never even went over the indictment with me.
Yeah.
I find that hard to believe. So here's the thing.
Actually, be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture of here.
Yeah.
So, the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment. After
Sir, the allegation.
That's why I'm pleading no contest.
I'm not going to
I'm
allow.
fine guilty. It's fine.
Here's the thing. I don't have to accept any plea agreement.
Yes, ma'am.
Okay. So you can, in that evading.
This moment right here is where things start getting legally complicated. The defendant is trying to enter a no-contest plea, also known as nolo contender. In many courts, that means the defendant doesn't admit guilt, but accepts punishment as if they were guilty. However, the key detail is that judges are not required to accept a no-contest plea, especially when there's already a negotiated plea. Agreement on the table. What the judge is essentially saying is, if you want this deal, you play by the rules of this court, and that deal matters. Because if this case goes to trial and the prior convictions are proven, the defendant could be sentenced as a habitual offender, which dramatically increases the punishment range, potentially 25 years to life. So now the courtroom tension shifts. Is the defendant misunderstanding the law or deliberately pushing the boundaries?
Arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea agreement.
If you go to trial, listen to me. If you go to trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do. But you're going to either accept responsibility and plead guilty or plead not guilty. Yeah. That's your choices. So let's go back then and cause number 2136426. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. He's saying assault family violence. The evading arrest is plead guilty.
It's evading arrest or detention with the use.
I'm saying.
I'm looking at your indictment.
He's saying you got indicted for.
I got that.
For evading. In 2014, you were
Hold
convicted
on.
of something else. Okay.
You've probably already tried. Let me take care of it this way. Give me just a second. Which one is being dismissed? 5-1 or
39051.
Okay. Make sure you don't get my information mixed up with his.
Who's?
Or whoever that information is. I ain't gonna say his name on the record.
That's not me.
36426. That indictment alleges in paragraph 1 that you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020.
Yeah.
How do you plead to that charge?
I just pleaded no contest. She didn't want to accept no contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not going to plead no contest.
Guilty or not? You plead guilty or not guilty?
So if I'm telling you no content, what is that?
It's nothing, and it's nothing. You're not allowed. I can take a plea of no contest, or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty.
I'm saying.
Period. I'm about to set your case for trial.
Saying that I'm not. That's basically saying that I'm.
We're not going to argue the law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I state that.
I'm not going to argue the law with
no
you.
Guilty. Just sign. Go ahead. That's guilty. Go ahead. That's what y'all want anyway.
Listen,
I'm cool, ma'am. Just go ahead.
Well, you're not. You're really not being cool, and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me the
nothing here.
Plead guilty. There
Okay.
you go.
So you plead guilty to evading arrest or detention
Yes,
with
ma'am.
the use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence December 5th of 2014. Is that true or not true that you have that conviction
That's
on
true.
your record? Okay.
And that's not the same
That's
case
okay.
as far as
Look-
evading arrest, ma'am. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
Exactly. And listen, so Mr.
that's
Campbell,
15.
Wow.
I think.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you.
Now, this is one of the most intense exchanges of the hearing. After several attempts to explain the options, the judge finally forces a clear answer: guilty or not guilty. The defendant repeatedly tries to frame his response as no contest, but the judge refuses to accept that wording under the current plea agreement. At this point, the judge also explains an important legal distinction: repeat offender versus habitual offender. A repeat offender still faces enhanced penalties, but a habitual offender can face drastically harsher sentencing ranges. The plea deal being offered avoids that worst-case scenario. So the defendant is essentially standing at a crossroads: accept the deal for 18 years, or gamble everything on a trial that could result in life behind bars. But the tension between the two continues to escalate.
Repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
No.
Okay. So I have let's go to the next case then. In cause number, and here's that indictment. In cause number 22-39050, you're charged with and in this case, we're just going on count one.
Count one only.
So in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
Pleading no content, but guilty now.
So are you pleading guilty to this charge?
Yeah.
Okay. And did anybody force you to plead guilty in cause number 22-39050?
We just answered it.
I know I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
I just pleaded guilty.
Okay. And nobody forced you to do that, right? Speak up so the record can take it
No,
down.
I think you did. You did, but let's go. So no.
Okay. So I have in both of those cases here on the tablet, some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker? The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving any right to appeal? Yes or no, please? Do you understand that?
I understand what we signed, the documents.
Okay. You have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed, okay? I'm not trying to, doesn't have to be that difficult. Just get in, get your deal, and get out. You're making this way more difficult than it has to be. Do you also understand if you're not a U.S.
He's confident.
I just printed the wrong stuff. Did I print both of the
Give him the
13 years in the institutional division of the Texas Department of Corrections? You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
So can you say that on record?
I'm on the
Yes.
record.
No, I'm saying say that how long I've been in custody.
I don't know. I don't have that information.
5 years.
Okay, you'll get all the credit that you are entitled to get by law. And cause number 2239050, also find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence, sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement and cause number 2239051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered 2239051.
For my time, sir.
Go back with the bailiff. 2239051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time, sir?
Go back with the bailiff.
Is you gonna bring me my papers for my time,
they
sir?
have it in the jail. No.
Excuse me?
No, they have it at the jail. No.
In the end, the courtroom drama settles with the judge accepting the plea agreement. The defendant receives 18 years in prison for the charges of evading arrest with a vehicle and tampering with physical evidence. Importantly, the judge orders that these sentences run concurrently, meaning they will be served at the same time rather than stacked one after another. However, the agreement also comes with consequences. By accepting this plea deal, the defendant waives his right to appeal, and under Texas law, he is also prohibited from possessing firearms or ammunition in the future. What started as a tense courtroom confrontation ultimately ends with a negotiated sentence, but not without some serious friction along the way. If you found this courtroom exchange as intense as we did, make sure to hit the like button, share your thoughts in the comments about whether the judge handled this situation fairly, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.